Good morning. Are you Marissa Fortune?
Good morning. Yes, ma'am.
And Ms. Fortune was previously in court, entered plea of guilty in cause number 25 DCCR 1117 to the new offense of credit or debit card abuse, and then entered pleas of true in cause number 24 DCCR 1156. It was a motion to revoke probation. And the agreement was for a 5-year deferred on the new case to continue her on probation, and in each of those cases, for her to be ordered to enter and complete the cognitive track of the ISF program, correct?
That's correct.
In addition, there was restitution in the new case, but I don't
The
see
victim
an
himself,
amount.
it was a credit card. number.
$301.66.
It was a credit card. The victim was not charged that, so that would be between the credit card company,
Okay,
if they were actually out. And I haven't heard anything from them.
you have not heard anything from the credit card company, then I'm not going to order it. That just makes it more confusing, I think. Have you heard anything or, okay, thank you, ma'am, and thank you for being here. All right, then, I have received that pre-sentence report, reviewed it, and the update. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes.
Any additions or corrections?
No, Your Honor.
Not concerned.
Okay, so Ms. Fortune, you're going to be given an opportunity today that you likely will not get again, okay? So I want you to take advantage of this. Everybody's willing to work with you, get you the help you need so that you can be successful on both of these probations. But I want to make sure you understand that if you're back in here on a motion to revoke on these cases, it is very likely that you will be found guilty in each of these cases, become a convicted felon, and end up in prison. Okay? Yes, ma'am. So I'm going to find in cause number 25 DCCR 1117 that you entered that plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but at this time I'm going to follow the agreement that you made and defer all proceedings and place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. And then in cause number 24 DCCR 1156, I'm going to find sufficient evidence to revoke that probation, but I'm not going to do that. I'm going to continue you on that probation and modify the conditions of it to include that you enter and successfully complete the cognitive track of the ISF program. Again, you do all of this, you're going to be given the tools that you need to be successful, and if you don't take advantage of it, you won't be leaving me many choices. You understand? I'm going to hand you in each of your cases, excuse me, the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. All right, good luck to you, ma'am. You can go back with the bailiff. Good morning, you're Logan Eaglin.
Yes, ma'am.
Mr. Eaglin, in cause number 25, DCCR 0897, and we've gone over this before, but I'm going to go over it, make sure we're all on the same page and you understand everything. In that case, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from October 26th of 2024. Your indictment alleges that you were previously convicted of burglary of a habitation, March 1st of 2013 in 2 different cases of burglary habitation on that date. And then on September 3rd of 2015, you were also convicted of prohibited substance or possession of a prohibited substance in a correctional facility. What that means is if you go to trial and you're found guilty in this case, and those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count 1 only, just the aggravated assault case, with a cap of 20 years as your punishment, which means you would be leaving your punishment up to me. I can give you 20 years, I could give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have a jury decide your case. I just want to make sure you understand the possible consequences if you go to trial and what your options are.
Yes, ma'am.
You understand all of that?
Yes, ma'am.
And you want to reject this and go forward with your trial, is that correct? All right, is there any evidence or discovery that hasn't been turned over that you guys are waiting on?
Not that I'm aware of, Your Honor.
So I will set it on the next available trial docket. Everybody will be prepared for trial, and we'll get your case tried as quickly as possible. You can go back with the bailiff.